Good afternoon, everyone. I'm Kathy Davis, and I'd like to welcome you to MPTF PAN's fourth quarter presentation, The California Exodus, How to Exit the State with Your Fortune Intact or Not. But before we get started on that, I'd like to take a few moments to thank Chung Che of Hochman, Sabin, and Wanamaker and Shram Hazani of Merrill Lynch. For the past 3 years, they have co-chaired the PAN Advisory Board, and along with other board members, Jeff Gerber of Framework Insurance and Financial Solutions, Tyson Beam of Gelfand Rennert and Feldman, and Jonathan Fitzgerald of Equinox Strategy Partners, who you'll meet a little bit later. They coordinate our presentations and sometimes up to a year in advance. And we are always like proposing and calculating and recalculating topics that we hope are timely, of interest, and are applicable to your professions. I couldn't have done it without them. And as the year closes, I want to thank you for your support. I would also like to mention that 2021 is our 100th anniversary and of assisting entertainment industry members in need. I mean, it takes more than dedicated employees, which we have, for MPTF to have endured this long. It also requires relevancy to a community and financial support. Having said that, I would be remiss if I did not mention that we continue to need your support. So please visit our website at mptf.com/donate and give what you can. Our goal is to have 100% participation from industry members. So even a small contribution will help us reach that goal. And just a few housekeeping items. This presentation will be recorded. And yes, it's recording right now. So if you have to jump off early, I can send you the link upon request. This presentation does qualify for CPE credit, and I will email you your certificates by Friday. And fingers crossed, I know I've said this before, but I really mean it this time. We plan to go back to the Beverly Wilshire next year for our PAN luncheons instead of just a presentation. So thank you and have a wonderful holiday season. And now I would like to introduce our Chief Development Officer, Courtney Bailey.
Hi, Kathy. Well, beautifully said. Thank you so much, everyone, for the time today. As always, it's an honor to welcome you all here. Yes, we're still doing these virtually. As Kathy said, we'll get back in person, but it's what an incredible topic today. I cannot wait to listen and learn. Thank you for all of our panelists to be here. We'll introduce Jonathan later, who you heard about. As Kathy said, which Kathy said it beautifully, this is our 100th year. It was a very different 100th year than we anticipated in planning what would be our 100th year a couple of years ago. Without being too redundant, no one could have anticipated a pandemic, but it speaks beautifully to our mission, which is being a safety net for the industry. And while we want to be as proactive as possible, you have to account for those moments that you didn't plan for. And that's really the heart of MPTF and why we've existed for 100 years, because as you all know, with your clients, yourself, this industry is tough. It's challenging. There's quite a disparity from the haves and the have-nots. And it's really kind of the responsibility of everyone, as Kathy mentioned beautifully, 100% participation to play our part to take care of each other. So again, thank you so many of you. I've looked at the guest list. I'm looking at our panelists. You all support our mission beautifully. And we really do, as Kathy again has hit almost every point that I was going to say, which is great. Kathy does such a great job. We need your support now more than ever. This organization needs to exist for another 100 years, at least another 10 years, at least another 50 years. And we can only do that by our 3 pillars, which is really donate, advocate, volunteer. So your financial support, incredibly important, of course, but being an advocate, your voice to your peers, to your clients, to let them know that we're here for them, should they need it. And this is, yes, we help below the line. And yes, we have this gorgeous retirement campus, but we help everybody, despite your status, despite the job that you have. So we want everyone to know that we are here. It really boggles my mind now after being here 3 years that people still don't know all that we do. So again, thank you for lending your voice about our social work, our financial assistance, mental health support, food delivery, volunteering virtually, in person, which hopefully we can do more. Yes, I'm the Chief Development Officer, so fundraising is a big piece. And we've enlisted the spirit of competition to get business managers to compete with each other and to give as much as possible. Entertainment attorneys, there's a showrunner challenge. So we want to make it fun. We want to make it feel like you're alumni, your university. It's just your tithing to give back, whether it's investing in you one day or your clients, your colleagues, or someone you may not even know. It's very important. I encourage you all, as Kathy said, of course, go to mptf.com to donate, but also check out what we do. Go to our YouTube page and hear recipients of service. It happens to be these stories told many times by celebrities. So you hear it from this beautiful voice, and these stories will really resonate, whether it's paying a bill, production was shut down, you're not working, a child got sick, a parent got sick and you didn't know what to do. And our social workers will be there with you throughout the journey. So thank you so much for your time, for being here today. Again, this is going to be great. I have the pleasure to introduce Jonathan Fitzgerald of Equinox Strategy Partners. He's the managing partner. He's incredible. He's a coach. He just does it all, and he's got such a big heart. And clearly, from his background, he'll be indulging in some shots with everybody later. But Jonathan, thank you. We love you, and the floor is yours, my friend.
Thanks, Courtney. Welcome, everybody. In 1978, the Eagles had a chart-topping hit, so appropriately entitled Hotel California. And in the event that I need to refresh your memory, here are some of the lyrics. Welcome to the Hotel California, such a lovely place. You can check out anytime you like, but you can never leave. I'm sure for some of our clients residing in California, oftentimes this song and these lyrics probably hit home all too closely. And many of us in the last couple of years have gotten those calls about, hey, I'm thinking about, or I've heard about the possibility of leaving. Could be a number of reasons. Tax is probably one of the biggest. And we're on the receiving end of those calls. And we thought that it would be an excellent discussion to provide you with a little more information, some more specific information on how this topic specifically can impact your clients. The other thing that I think would be important to get out right at the beginning of our discussion today, we will be talking a little bit about the Franchise Tax Board in California and how they've got their meat hooks in just about anything tax revenue related possible. I looked up on the website to get their mission statement, and just in case Hotel California wasn't enough of an issue, let me share with you the mission statement of the California Tax Franchise Board. It says, to help taxpayers file tax returns timely, accurately, and to pay the correct amount. And it's that last part that that they will go to all extremes to make sure they accomplish that mission, and you will hear about it in the next 45 minutes. So to get our discussion kicked off today, and by the way, for any of you that have questions along the way, feel free to throw them in the chat. I will be monitoring the chat, and to the extent that we can get you to your questions, we definitely like to address those throughout the course of our discussion today. To get us kicked off, and I'd like to start with Dennis, I want to get from each of our panelists a very brief introduction, and then also mention how this issue likely comes to you. Are you getting client calls? Are you getting people that want to have strategy sessions with you? So Dennis, can we start with you on that? Brief introduction, and then how does this topic impact your practice?
Thank you, Jonathan. I'm happy to be here. I'm happy to be here on this panel with such a diverse group of people. So I think what we will provide you is a presentation from a lot of different perspectives. Anyway, I'm a partner with the firm Hochman Salkin Toscher Perez. We are a tax litigation firm, so we really are front and center when it comes to this issue. we see the issue in FTB audits, which I've described as some of the most intensive and intrusive type of audits that we ever get involved in. And I would say within the last couple of years, I have fielded as many calls about residency, people wanting to know how you leave California, as I have in the last 20 years. So it's not a surprise to me that so many people were interested in attending this. And so that's how I see it.
Thank you, Dennis. Laura.
I'm Laura Zwicker. I'm partner at Greenberg Glusker, and I am primarily a trust and estates tax lawyer. So I do not tangle with the Franchise Tax Board. I always call Dennis or one of his colleagues when we have one of those issues come up. So my focus is on trusts leaving California or accidentally coming into California. I get a lot of calls from lawyers on the East Coast where there is a trust with a beneficiary who suddenly moved to California and is worried about getting stuck in Jonathan's hotel. So that's where it comes to me.
Great. Thank you, Laura. Mark.
I am Mark Pariser. I am a partner at the business management firm of Dunn, Pariser, and Peyrot. And this issue comes up primarily in a tax planning context. I get people who ask me questions about moving out of California, primarily for saving taxes. We've had clients in the past who are professional athletes and they get traded to a team that's out, that's out of state, and now they realize that they don't have to, maybe they don't have to pay California tax. And so it's, trying to lay out a roadmap for how to accomplish somebody getting away from the state.
Assuming that's even possible, Mark. Thank you.
Well, yes.
We will find that out in short order. Stephanie.
Thanks, Jonathan. So my name is Stephanie Blum. I'm a partner at Reuber Raucher Blum. I'm a certified family law specialist. Our firm does civil litigation and family law. I only do family law. I'm in charge of the family law department. This issue comes up for me and always has in the context of people wanting to relocate. So typically divorced people, one parent wants to move out of state, and then the issue becomes what happens to the kids.
Excellent, thank you. To get our conversation kicked off, Dennis mentioned something during his introduction where he talked about residency, and I think it's important to impress upon everyone that the term residency in this instance is almost a term of art. He didn't just mention it by happenstance, but Dennis, do you want to expound on how California defines residency and kind of treats residency in the context of some kind of an exit?
Well, the regulatory definition of actually the statutory definition of residency is someone who is in California for other than a temporary or transitory purpose. So, I mean, you have to think about that, being in California for other than a temporary or transitory purpose. So I will assume, although I've heard enough about you, Jonathan, and you're in front of a bar, you probably, I don't know if you're here for temporary, transitory, or permanently, but I think all of us are residents of California because we are here permanently, at least in the foreseeable future. And the FTB will start their analysis with that. And if somebody leaves California, the question is whether they did it in a way that allows them to argue they are non-residents of California, so they're no longer here permanently. But there's also a second part of the test, and that is the person has to prove that they are no longer domiciliaries of California. And in that context, if you're talking about somebody who's been here for a permanent period of time, is born and raised or has lived here for a long time, then that person will be considered by the FTB as domiciled in California if also the FTB can say that they were outside the state for a temporary or transitory purpose. So if you think it in terms of, let's say you have lived here for an indefinite period of time and you want to move to Nevada. So you sell everything, you might have some ties here, and then you go to Nevada. But let's say you keep coming back to California because you like spending summers here. Then you start to blur the picture. And even though you may have bought a house in Nevada, the question then becomes, are you there permanently? You keep coming back to California. And what is your intent? Because part of the domicile test has to do with whether you intend to be there permanently or whether you intend to return to the state of California for any reason in the future. So like what Mark was saying, these professional athletes, okay, so it's a professional football player that signs a contract with the Miami Dolphins, and it's a 5-year contract. If they live in Miami or for 5 years, but then they come to California, they very well could be challenged for giving up their California residency because the FTB has the ability to look in retrospect what happened during that period of time. And if they start to find that the person was here during the off season, the person's family is here, child continued to stay in school, then you run into problems. So
And
that's
Dennis,
how I see that.
does the FTB just take your word for moving to Miami, or do they go to even further lengths to trust but verify?
You know, I sometimes wonder whether they trust or they verify. They just go on their own track on what they believe. Obviously, as a professional, and I'm sure that Laura could speak to this as well, you do your best to put forth your most persuasive case, and you support that case with corroborating evidence. So the FTB, I've always viewed the FTB as a maybe they want you to pay the correct amount of tax, but it's the correct amount of tax in their eyes. I view them as a revenue producing agency, you know, beginning and end. And so when they choose somebody for audit on this issue, they believe that there is a good chance that the facts are going to come out in their favor. At least that's what I believe, because so much of the audit activity that takes place in this area is so intrusive. So even if they just have an inkling that you might be a California resident, even though you live in Wyoming, for example, they're going to go through all the paces. They're going to check all the utility bills at any property that you maybe have maintained here in California. They're going to check your credit card slips. They're going to really cover the whole territory with questions. And so, yes, it's our position to represent people in audits and appeals of those audits and put forth our best case, but they will do a lot of their own fact finding on their own.
Yeah, thank you. Laura, you mentioned in your introduction that you handle the trust element of planning. And I'm curious to know if California, Dennis talks about where someone spends time in terms of their physicalness. I'm wondering, does a trust follow someone wherever they may be? Are there situations where someone could legitimately leave California, but some of their trusts remain here?
Yeah, and I actually have a quick question for Dennis. So I deal a lot with cross-border clients. And so we have a California resident who wants to establish domicile overseas. In other states in the United States, it's really hard to unstick yourself from that US jurisdiction immediately to a non-US jurisdiction. And so we ask them to establish domicile in another US jurisdiction before going overseas. Does the FTB draw that distinction as well?
You know what, I haven't seen that come up in any cases that I've handled, but it's very interesting that you raise this because I'm talking to a client now who wants to relocate to to Europe, to a country in Europe, but wants to avoid full taxation in that country, and in order to do that, has to establish to that country's satisfaction that the connection here in the United States is stronger.
But not to California.
But the last place the person lived was California.
Yes.
So we've told that person, listen, you have to choose another state to draw that connection before you start considering a domicile in this new country in Europe.
Yeah.
And so it's very interesting you raise that issue, because literally I wrote a letter on this yesterday.
Okay, so now to Jonathan's question. So the answer to Jonathan's question, like the answer to most legal questions, is it depends. So if your trust is your revocable living trust, it's going to follow you pretty cleanly wherever you go, because for income tax purposes, it's a grantor trust, so it's treated as you. And wherever you're living, it's going to follow you. But let's say you created a trust for your kids. And the trustee of the trust for your kids is your business manager, Mark, and he is a California resident. California will then tax your trust for your kids as a California tax resident because Mark is the trustee. So California looks at two factors when determining whether a trust is a California resident. It looks at who is the trustee and who are the non-contingent beneficiaries, who are the beneficiaries who are currently absolutely entitled to distributions from the trust. So depending on the answers to those questions, the trust may be 100% taxable in California, or it may only be partially taxable in California. The one thing we don't care about in California in terms of deciding where to tax a trust is who the settlor was and where they were living when the trust was created. You do have to worry about that in New York. In New York, they only care about who the settlor was when the trust became irrevocable. So another tricky thing as people and trusts are moving around the country is to know how the jurisdiction you're leaving and the jurisdiction you're moving to will determine tax residency for a trust.
And Laura, does the FTB care about, or does the state care about on some level, what the specific assets in those trusts are?
So this is true for individuals or trusts. All California source income, so generated by a source in California, is subject to California income tax, whether you're resident or non-resident, whether you're resident in Nevada or Switzerland or wherever. So if you have a trust and Mark declines to serve as trustee and designates his friend in Nevada, if we have a California apartment building in the trust, that's going to be California source income, and that's going to be taxed in California, even if we don't have any fiduciaries or beneficiaries in California any longer.
So what I'm hearing is California real estate seems to be a major trigger as to how anyone's wealth, how the FTB kind of considers some of these issues. And in a second, I'm going to have Mark talk about kind of this idea of how do you sever all of these ties, but real estate, physical real estate in California seems to be a big deal with the FTB.
Yep, it's going to be California source income.
So another question before we move on, what if you have a client that's living outside of the United States, foreign, they have a liquidity event where there's tremendous revenue that is generated, substantial capital gains on that revenue, and then they move to California. Is there any way California can tap into or tax that event that happened before the person was physically here?
I would say no. You know, all residency issues are sort of looked at the time the transactions take place. So if you've got a transaction that takes place before a person is a California resident, then California doesn't have a claim on the assets. Of course, the real question is were they a resident or not at the time the transaction takes place? And that's really, I think, a function of, you know, the the amount of California ties they have, the domicile issue that, Dennis mentioned earlier, comes into play. But generally, if somebody is thinking of moving to California and they're going to have a large liquidity event, they should minimize their ties to California before coming to California, or make sure their ties are not that great to California.
And even for those clients, Mark, that are excellent about that bright line, they got this liquidity event done and over with prior to physically coming to California. It doesn't necessarily mean that the FTB won't try.
Well, yes, they're very aggressive. They're the most aggressive state. Maybe New York's also a very aggressive state when it comes to pursuing residency cases, because the tax rates are so high, and they know that people want to avoid the taxes. And, we have, a state right next door that's a no tax state.
Very enticing. So Mark, in terms of keeping things as clean as possible, when you have a client that approaches you and says, hey, we're considering this right now, the idea of how can you navigate this for me, wink, wink, to where we don't really have to move, but it looks like we have moved and we're going to try to game the system a little bit. That works, right?
You could keep telling yourself that, and maybe one day you'll believe it. You really need to cut your California ties to avoid getting taxed as a residency. You really can't play games with that. The FTB, I think Dennis mentioned that it's a very intrusive audit. They look through every single bank account. They look for canceled checks. They look for the debits that are on the statements. They want to see where they're originating. They look at every single credit card charge. They'll look at utility bills. They'll look at phone bills.
They're like a spouse going through a divorce.
Exactly. Except for they're even more hostile than an ex-spouse.
Not possible.
I mean, this idea of, I'll set up a Nevada PO box and get my Nevada driver's license. While a driver's license is a factor in determining a residency audit, they will discount that, especially if you still have if you still own your primary residence. So going to one of the ways of severing ties, one of the most important things a person can do is sell their primary residence. Or in the alternative, and I still say selling is better, at least rent it out for a long-term lease so that you can show that it's not your residence anymore. I had an audit that I was involved with many years ago. It was a high-profile actress, and her home was damaged so much by the Northridge earthquake that it was uninhabitable. And the FTB still pointed to that and said, you have your primary residence. And we were like, it was red. Basically, it was red tagged. It needed to be totaled, but they used that tie to say that she hadn't left for other than a temporary or transitory purpose.
Yeah, and just to further communicate, folks, the extent that the FTB will go to, one of the attendees in today's session said that they had a situation whereby the FTP actually looked to see where their pets were being treated in terms of a veterinarian to determine, to help determine, where they spent their time. I know in preparation for our discussion today too, there was an example that was shared where I think it was a sports player. He had been traded, but he still retained a residence in California where his mother lived. And for some reason, his kids were continuing to go to school here. Maybe they wanted, they didn't want to have to move them during the school year or something. The FTB actually sent an agent to the school to interview the teachers as to whether or not they had seen this taxpayer's kids recently. And I know some of this may sound extreme, but to Mark's point, this just goes to show you how interested the state of California and the Franchise Tax Board is in making sure that particularly if you're a high revenue generator for the state, they are going to go to just about any extreme to make sure that you are in fact, you've severed ties. And by the way, not only does that have to be ties with your vet, but Mark, I assume that your primary care physician, the social clubs that you belong to, I mean, all of that could be fair game for the FTB in some kind of an audit.
It is fair game, and that's where the problem lies, particularly for people who have lived in California for long periods of time, or maybe even the entire lives. It's one thing to give up a club that you belong to in California, but now you're going to move to another state and it makes sense to join another club. But a lot of people don't want to necessarily give up the doctors that they've been seeing for 20, 30 years. And they figure, okay, I'll come see my doctor when I visit California.
Or their managers or their agents.
Well,
or
yeah. And again,
whoever.
Particularly for people in the entertainment business, where if they want to live out of state, but their representatives are in California, you know, it's the Franchise Tax Board, it's like heads they win, tails the taxpayer loses, because if there's a factor that favors a taxpayer in their non-residency claim, the FTB goes, not important. It's almost irrelevant. Whereas if there's a factor that points to California residency, they overemphasize it. They make it like it's the most important thing, and it's very frustrating dealing with them because it's a religious fervor with them. I really believe that.
Yeah. And Stephanie, I'd like to bring you in on the conversation to in the context of family law. How does California look at like this residency or where someone is domiciled? Is that often taken into consideration on custody issues or other family law related issues?
So in order to file for divorce in California, you have to have been a resident of the state for 6 months and the county for 3 months, although you can get around the residency requirement by filing for legal separation. And then you can like run out the period and then go and file for a divorce. But what was interesting in taking a look at some of the other states, that when you and I, Jonathan, had a conversation about like where people are going to, I'm thinking that people should move out of state and then get divorced based on the laws of some of these other states. If you have wealth and if you hate your spouse and you have kids, oh my God, there's so many better places to live to reduce your support obligations. So just another fact. I mean, I know this sounds crazy, but if you're counseling clients, I might want to find out how their marriage is going. Because, for example, Nevada, so in addition to having no state income tax, get this, it seems that child support is capped at $1,165 a month. So that's less than $1,200 for child support a month. Do you know how much parents can be ordered to pay in California? A lot more than that. So there's, I mean, in Texas, for example, you could be married, it seems, for 30 years and your spousal support obligation is capped at 10 years. Whereas in California, if you get divorced after 10 years, it's really, anyone's guess as to how long you're going to have to pay. So there's some incentives there's more than a tax incentive to leave California.
So Stephanie, what are the psychological ways then that you can get your soon to be divorcing spouse to hold off and decide to leave with you?
I think you have, yeah, right. Well, I think you have to have already left maybe, or I don't know, appease them for a little while.
Yep. Thank you. Dennis, coming back to you, are there specific triggers that either the state of California or the FTB that seem to be, kind of red flags for them that we should be looking out for? We've talked about, a primary residence in California, but are there other triggers that could execute some kind of an audit?
Sure. I mean, every case is different, and I apologize for any background noise because the leaf blower is going full force next door. But in any event, yeah, the biggie really has to be the personal residence, because the personal residence is one of the largest factors that is goes into the determination of domicile. Also, family activities like where the kids go to school. That's a big thing. Just real property ownership in general, and actual presence. On the issue of domicile, the burden of proof is on the person changing domicile. So if you move from California to another state, the burden of proof is on you to prove that you're no longer a California person. And it's the definition of domicile as it's set forth in the regulations is interesting, because it talks about your domicile is where you have a present intention to live permanently, unless an unexpected event it induces you to change your domicile. So someone who says, well, you know, let's see what it's like to live in Scotland for 5 years. Well, and then if you come back to California after 5 years and there's no discernible event that caused you to do that, then you're open to being audited for that 5-year period that you claimed you were no longer a California person. Also, in the definition of domicile is the concept of where is it that you live, and then if you leave there, do you come back to that place? So that may sound pretty simple, but you know, maybe not. If you come back to that new place, and if you come back to a place in Newport Beach, it starts to blur. I've recently spoken to people who said, well, I want to leave California, but I'm not sure where I want to be. I've got this big yacht and I'm going to be doing this, I'm going to do that. Well, not good enough. Domicile, you must have a domicile at all times. And if you leave California and you sail around the world for a year, I can assure you, you will be considered a California person. You can't be a citizen of the world or a resident of the world. So
I thought there was a place called the Isle of Man. Dennis, can you not claim that as your?
Good luck, but I'm here. It's a pretty small isle. I'm not sure you want to be there all the time, but yeah, you know, it's. I do want to bring to the attention 2 cases, and these you can just Google these cases. The one is the Bracamonte case. That's Bracamonte. And that's a recent case that is a precedential case decided by the Office of Tax Appeals, which is the body that you try these cases in front of before you go into Superior Court. So that is actually quite instructive. And that case, you'll see it's all about the personal residence, but the person really did a lot in order to move. But at one point, the judge said, Mr. Bracamonte, it doesn't matter what you intended to do, it's what your actions show that you actually did. And they didn't sell their personal residence before taking on a permanent residence in Nevada. Also, for just amusement, if you Google the Hyatt case, Gil Hyatt, Hyatt, Mr. Hyatt fought. I mean, it was unbelievable. He fought with the Franchise Tax Board for at least 20 years on a residency issue. In his case, he actually at one point had a several $million judgment against the FTB, which was later, I think was later reversed, but it went up to the US Supreme Court. And I mean, it was amazing, but it just shows the tenacity. Well, there was a tenacity on Mr. Hyatt's side, but the tenacity of the FTB. So I hate to be so alarmist about this because I am an optimist by nature. but it's something that you really have to think through before you decide on leaving California. It's the smartest thing to do. Think through it and be advised.
Thanks, Dennis. And by the way, folks, I threw some links to both of the cases that Dennis referenced in the chat. So if you want to read up, I'm sure the reading is excellent nighttime reading. It is riveting. You will absolutely love it. If I were you, I'd rather you just call Dennis and get the summary notes from him, but feel free. One last thing before we move on to understand a little bit more about how California treats trusts and income. Dennis, you gave this example about someone getting on their yacht and traveling for a year. Mark talked about getting rid of doctors and advisors and your agent and all this other stuff. Because there is no bright line test, essentially what we're telling folks, what we're advising those on the call today is the more ties you can sever, probably the better or the stronger argument you have with the FTB. It doesn't necessarily mean that if you keep your doctor in California, that automatically will is a losing battle with the FTB. But essentially what we're saying is the more you can show that you have ultimately moved and transferred to a different state, the stronger your position is going to be with the FTB. Is that essentially what we're getting at here?
Yeah, it's really a closest connection test and a permanency test. But let me give you an anecdote that obviously you can't cite to this and say, CFTB, I'm not a resident, but I do have a friend who had a very high position in a very large corporation, and he retired. And although he has grown children who live in California, and he did keep his residence here, but he does rent it out. He moved to another state. But one of the things he comes back to California for two principal reasons. The first reason is he sits on 2 or 3 boards here in California. So he comes back for the board meetings. And obviously he wants to visit his children and his grandkids when he's there. So he's very meticulous about keeping a diary of whenever he comes back for his board meetings. He indicates that's the purpose of the trip, but of course he has a couple of days on either side. He visits with his grandkids, etc. He can't be criticized by the FTB for that. That is not a residency case is not made from that. So it's a matter of record keeping in the event the FTB does come knocking, you're prepared for it. So again, he wasn't willing to cut his ties on the boards. 2 of the 3 are nonprofit boards, and he likes the work. And I don't think the Franchise Tax Board, I mean, they do some pretty vicious things sometimes. I don't think they would ever cite to that, sitting on a nonprofit board in California as a reason for residency status.
Right.
If I just may add something really quickly before we move on, one of the things that they also look at, and it was mentioned in the Bracamonte case that Dennis mentioned, is time spent in California versus the other states. And in that case, one of the reasons the taxpayer lost is because in process of moving to California, they were still moving from California. They still spent more time in California, owned their personal residence, even though they were in the process of severing ties. And it becomes important because the state will look at, were you a resident or not at the time a particular transaction takes place? This goes back to Jonathan, what you were asking earlier. If somebody has a liquidity event before they become a resident, can California get it? It just depends on the ties that they have to California. Likewise, if you want to sell your business, just make sure you're not spending a lot of time in California. You've sold your residence. You've severed as many ties as you can before the liquidity event takes place.
Great. Thank you for that clarification, Mark. Laura, let's change topics a little bit and talk a little bit more about how California treats trusts. I know you kind of mentioned it a little bit earlier on the call, but from an income perspective, from an administrative perspective, can you give us a little more insight into that?
Sure. So for income tax purposes, we need to know whether the trust is a tax resident or a tax non-resident. As we touched on before, a non-resident trust is going to be taxed on its on its California source income only. So anything that is sourced in California, whereas a resident trust is taxed on its worldwide income. So how do we tell whether we have a resident trust or a non-resident trust? We look at who the fiduciaries are and who the beneficiaries are and what rights they have. So the first part of the test is who are the fiduciaries? And I'm using the word fiduciary because that's the word in the statute. They didn't limit it to trustees. So in modern trusts, we use all kinds of people with all kinds of names. There might be a trust protector, there might be an investment director or a distribution director. What the FTP cares about is who holds the trustee type powers, who holds the power to make investment decisions and who holds the power to make distribution decisions. So oftentimes, even if a trust will say the trust protector is acting in a non-fiduciary capacity, if they have powers that make them trustee-like, the FTP will count them as fiduciaries in determining whether we have California resident fiduciaries. So the residence of an individual is exactly what Dennis and Mark have been telling you about. Where are they domiciled? Where is that person resident? And so if we know we have someone who really doesn't have ties to California and they're an individual, we're safe. That person doesn't count in dragging the trust to California. If we have an entity, a business entity, whether it's a professional fiduciary or some business entity we've created to serve as trustee, we care about where the principal place of administration for the trust is with respect to that entity. So you could have a Nevada corporation with no California people on the board and no California officers, but really they're operating through the family's family office, which is in California. We'll say most of the administration relating to that trust is happening in California, even though we have a Nevada corporation. So for a corporate trustee, for a non-individual trustee, we have to look at where the trust administration activity is located. So it's even more complicated. So let's say we've got two trustees. We've got Mark and we have Mark's friend in Nevada. For California income tax purposes, California is going to say, this is a partial resident trust. Half of the income is taxed in California, half of it is not, because we've got one fiduciary who's California resident and one who's not. Let's say we've gone through that analysis. We then have to look at who the beneficiaries are. So we need to know, is a beneficiary a contingent beneficiary or a non-contingent beneficiary? And that definition is different for income tax purposes than it is for traditional trust purposes. We would say that someone who is permitted to receive income from a trust in the discretion of the trustee, that's a non-contingent beneficiary in normal trust language. But for income tax purposes, what we care about is whether the trustee must distribute income to them or whether it's purely discretionary. So if we have a discretionary beneficiary, that beneficiary is not going to be non-contingent and they won't tag us to California. If we have a trust that says we're going to distribute the trust income in 3 equal shares, and we have one beneficiary who's California and 2 who are not, under this test, 2/3 of the income will not be taxed to California and 1/3 would. Now combine that with Mark and his friend in Nevada. We would first say, okay, we have $90,000 of income. We're going to take 45 off the top because Mark is California. And then we're going to do the analysis at the beneficiary level with the remaining $45,000 of income. Is that enough to make your eyes glaze over?
Yeah, and so I'm thrilled that it's so clean cut, Laura. This is absolutely awesome. What I'm learning from this is, at least from a trust perspective and the way that it's set up, ambivalence is kind of a good thing in that instance.
Um,
Isn't it?
I think it's complexity rather than ambivalence. I
Okay.
mean, the factors are similar to the factors that Dennis and Mark were talking about from an individual standpoint. I'm just adding about 6 different factors that you have to throw into the mix in determining whether your trust is California resident or not and how its income is going to be taxed. And then you get to, if you are a non-California resident trust, but you have a contingent California beneficiary, what happens to the income when you make a distribution to that beneficiary? And the answer is that income is going to be taxed in California, even though it wasn't earned in this year. So you could have income that was earned 10 years ago and under the trust terms is added to principal. When we make a distribution from that principal to a California resident beneficiary, California says that income, we're going to look back 10 years. We're going to tax that income to you plus an interest factor, which is similar to the way foreign trusts are taxed under the US tax code. So we've got this sort of throwback tax or interest charge on the distribution to the California beneficiary, even if the trust was truly non-resident and shouldn't have been paying California income tax during that accumulation period. So there are a whole bunch of different factors. And before you move off, I want to tell Stephanie one good thing about trusts in California and divorce. In California, if I have my separate property trust that my parents created for me, the judge is not going to reach into my trust and give some of it to my spouse as community property. In East Coast states, Massachusetts, and I think New Hampshire, you can have an irrevocable trust created by grandparents that is for a whole class of beneficiaries. And the courts will reach in and divide what we think is this sacrosanct separate property and start handing it out to your spouse. You're damaging your cousins and your nieces and nephews, and they don't care. So there are some tiny silver linings in California, not many though.
Well, I have a question for you, Laura, that came up today, in fact.
Go
We
ahead,
had
Stephanie.
Grandparents are very unhappy that the court made a support order that took into account the gifts that the grandparents had been giving their son. Literally, the court imputed like $30,000 a month to this man, and he's having to pay support on money that he now doesn't get because the parents said, forget it, cutting you off, done. But more than that, so we'll go back and we'll try to modify that because, of course, once the gifts stop, we have a good argument on that front. But more than that, apparently there's a trust that provides for mandatory distributions. And the grandparents have said, we're not making them. So actually, that's my next question. What happens, and maybe this isn't for today, and you and I need to have a conversation later, but what can the family court say, well, too bad, we're going to impute it to you because it's mandatory? Like, what happens there?
If it's mandatory, it's mandatory. And there's actually a California Supreme Court case and Ninth Circuit case on that, not in the divorce context, but the creditor's rights context outside of divorce. And I can send that to you. But if it's mandatory, the creditor can sit there and the trustee can be forced to distribute. If it was discretionary, that's super interesting, right? So you have this discretionary trust where presumably an independent trustee has been making distributions for support during the marriage, and then all of a sudden decides, oh, no more distributions for you. That is more nuanced, but where it's mandatory, and the trustee is required to distribute it, and I'll send you the case sites.
So what happens when the trustee doesn't do it, even though they're supposed to?
There's a probate code provision that allows the creditor to go to court and compel the trustee to make the distributions.
But what if the creditor doesn't? So the creditor, the son, doesn't want the money, right?
Yeah, isn't the creditor the wife who wants the?
Well, there's no order yet. So I mean, she's the one who, the son is the one entitled to the money. He's saying, don't give it to me. The wife is saying, give it to him because I want it.
Right. So under the California Supreme Court case, the wife would be entitled to go to court and compel the distributions.
Those grandparents are not going to be happy to hear that.
Sorry, don't introduce them to me.
Even though it will strain a little bit, Stephanie, so it's legitimate for a judge to take into account, trust assets for a support order. It's not based on earnings.
Well, so that's not. Not really. So that's not assets. We're talking about income.
Income, okay.
So when it becomes income, it doesn't, the character of the income doesn't matter for support purposes. If we're talking about dividing community property and it's separate property money, that would be off to the side. I mean, that wouldn't be subject to division, but just because it's not subject to division doesn't mean it's fair game when we go to calculate support.
Interesting.
And just very quickly, Laura, before we get off of the trust issue, because apparently we can never leave California and we're stuck here, what do you generally, from a big picture perspective, advise your clients that may want to move assets outside of California with the thought that at some point in the future, maybe it's retirement, maybe it's something else, they're not paying that extra 13.1% on whatever assets they're able to unload out of California?
So actually with trusts, it is possible to move them out of California. So our two tests are, where are the fiduciaries located and are there California resident non-contingent beneficiaries? So I would just tell Mark, please step aside. We're only going to use your friend in Nevada as trustee. And this is a little bit more complicated when we have trusts created by grandparents and they're old-fashioned trusts and they have mandatory income, which I would never, ever, ever allow my clients to do because mandatory income is bad in all sorts of ways. Stephanie's example, the example of how do we get it out of California. But if we have a trust where we have non-California fiduciaries and we don't have anyone who receives mandatory income from the trust, we can allow the income to accumulate California tax-free in our trust as long as it's not California source income. And then the question is, do we need to make a distribution at any point to a person who is California resident? And if we do, we know we're going to pay some tax, but that's probably not going to be on all of the income that the trust has accumulated over time. So trust, the moral of the story is trust can move out of California probably more easily than individuals.
Yeah, so that's a strategy. I mean, perhaps that's somewhat of a compromise for some of our clients that do want to offload some assets from California taxation. So there are some strategies there that clients can explore if they will call someone that understands what they are and can navigate through them. Thank you, Dennis.
Jonathan, I have a related comment to that about moving assets out of California or moving or buying assets in other states.
Yeah,
and it has to do with Section 1031. If, for example, you own a rental property in California and you decide that you want to move to Florida, and at the same time you want to sever all ties and sell all your assets, but you don't want to generate a gain that is currently recognizable, you can use 1031 to exchange into a replacement property. If that replacement property is in Florida and the 1031 is done correctly, you avoid both state and federal taxation gain recognition, assuming that you do it, this year, and then after you sell the property, then exchange the property, then you move to Florida. The question then becomes, do you ever have to pay the state of California now that the gain is locked into a Florida piece of property? And the answer, sadly, is yes. There is a reporting regime that you have to follow every year that replacement property is held by you. You have to file a return in California and tell them that you still have that property. And then when that replacement property gets sold, California will then request the gain that you would have recognized had you recognized it the year that you sold it when you were last a California resident. So as amazing as that sounds, you could be living 10 years in Florida, getting income from this great rental property in Florida, and 10 years from now, you have to write a check to the franchise tax board for the gain that you deferred 10 years prior when you were a California resident.
And
Sorry
back,
about that.
and back to my lyrics, you can check out anytime you like, but you can never leave, folks. Thank you very much for that, Dennis. Another thing that I'd like to address, and Dennis, I'm going to come back to you on this. There are a lot of people on the call that represent creative types. There are lots of people on the call that have represented clients who, because of COVID, have perhaps left California, whether permanently or temporarily. They're making money elsewhere. Dennis, I'd love for you to address that a little bit and how the FTB or California is recognizing those situations.
Okay, I'll sort of give you the 25,000 foot level because you get into a lot of complexity and minutia, and I'll leave the complexity to Laura because she seems to be really good at that. But if you are an employee living outside of California, but you're employed by a California company and you receive a paycheck, you can exclude your income is not considered California source income because the determination is made as to where you're providing the services. And if you're sitting in Utah in a mountain house and you are a resident of Utah, let's not forget that you are a resident of Utah, then even though you're receiving money from a California company and you're an employee, it's not considered California source, so you don't have to pay California tax on it. However, if you're operating as an independent contractor in Utah, and you've lived in Utah all your life, and you are receiving payment for your independent contractor services from a California company, that could be viewed as California source income to the extent the services you provided are used and enjoyed by the California company. And there's a case out there involving, I believe, screenwriters who lived in Arizona and wrote screenplays for a production company here in California. I spoke to a travel writer who lived in Alaska who called me because she said, I've lived here all my life. California wants to tax me on a couple of articles that I wrote for a California magazine company. And it's considered California source income to her.
Great. We've probably bagged on California enough. I want to throw this question out to our panelists, and Mark, maybe we'll start with you. Any benefits of when your client calls you and they're suggesting that the possibility of a move? Is there anything that California does provide? I know Laura talked a little bit about them with Stephanie. Anything else that clients should take into consideration that perhaps would be better in California than other states?
Yeah, these are more legal issues than financial issues, but it could have financial impact. California and a lot of states, but a lot of states don't have this. There's a posthumous right to publicity or name and likeness rights in California. So if a California resident passes away and their name and likeness has some value, the heirs have the right to exploit that and protect the rights as though it were their own. There are limitations and whatnot, but it is something to consider, particularly if a high profile person wants to leave and what kind of legacy they want to leave. I know there's an issue with contracts between talent and their managers. California, I think, has a 7-year limitation. So if talent wants to break their deals with their management company, there is California is very talent friendly in how they view contract disputes between talent and their representatives.
Excellent. Any other benefits from our other panelists that we should bring up before we move on to our final?
California has no gift or estate tax, so that's big.
Yeah, depending on the size of the estate, that could be significant.
Right. And some no income tax jurisdictions like Washington State do have a very substantial inheritance tax. So you need to be careful about both sides of your tax coin when you're moving.
Good.
I have one for you. California is
Yeah.
a no-fault state, so if you've been cheating on your spouse, the court's not supposed to care.
And when you say not supposed to, you kind of left it open there, Stephanie.
Well, you never know what's going to happen when you litigate, right? I mean, any judge on any given day can do anything, especially in my world, because family law judges have a ton of discretion. But it really, it's a put, well, because they're trying to bring fault back, actually, although they don't say that. You can get like fault, I mean, for example, domestic violence, if you're accused or you can prove domestic violence, that's a factor that comes into play. So even though it's supposed to be no one cares what you did to whom or why you're getting divorced, it's actually, I think it matters a little bit.
Got it. Great. We're just about up in terms of time, folks, but I'd love to get
Jonathan, I have
Oh.
one comment, and that is,
Yeah.
it's not so much a benefit of California, but it's a benefit from the Franchise Tax Board. They helped put 3 of my children through college, so that was a benefit that I that I had.
Are you suggesting dealing with the FTB is not inexpensive, Dennis?
Well, I'd like to get paid for my time.
Yep, I gotcha. So as we kind of wind up this discussion, folks, I'd love to hear from each of you. And Laura, perhaps we can start with you. If there's kind of one last piece of advice that you may have for those attending our session today, I'd love to hear what each of those is. And then Kathy, we're going to turn it back to you. Go ahead, Laura.
So my advice is being careful and thoughtful. So clients are often in a rush to move or in a rush to buy something or sell something, but taking the time to think through the consequences on both sides, I think is really important, and taking the time to bring in the right expert professional. So as I said, I send a lot of things to Dennis's firm because I don't have the expertise in dealing with the FTB. And similarly, I'm sure Dennis is not going to do gift and estate tax returns. So taking the time to find the right professionals to do the job, I think is important.
This is not an exercise that you should take into your own hands. Thank you. Thank you, Laura. Dennis.
Yes, I have to echo what Laura says. I mean, she said it so well, not about our firm, but about what clients should do. There have been a few things said today where you've described certain situations, and what rings in my mind is, yeah, I know what those people are. We call them clients because they took action and then they came to see us. What do I do about this now? And so it is of utmost importance that people recognize the issues, and then they think the issues through with the appropriate professional at all levels, because there's a lot of misinformation out there as to what it takes to become a non-resident person after you've lived in California for a long period of time. And so that's what I have to say.
And if the complexity wasn't enough, things are changing from one year to the next. And even if you think as a trusted advisor that you really understand how to advise your client one year, the weather could change in 6 months and things could be totally different. So getting to your trusted advisors early and often is probably a great piece of advice. Thank you, Dennis. Mark, would you like to go next? Your piece of advice?
Yes, I would say similar to what the other people have said. It's plan, plan, plan. It's a complicated area of the law. It's very facts and circumstances based. So if you are a person anticipating a large and a liquidity event, you want to start the process well in advance of the liquidity event so that by the time it happens, your case for non-residency is as strong as it can be. And I would just throw in, get rid of that primary residence, or at least rent it out, because that's one of the biggest things that the FTB looks at.
Thank you, Mark. And Stephanie.
Well, based on what all the other professionals said, I'm thinking that another way to do, so if you're representing somebody who's divorced and who has kids and who's thinking about moving, they should be trying to convince their ex-spouse to also move, because now you've moved the whole family to the new state, which certainly would sever ties with California, and it might solve a whole lot of other problems too. And shockingly, I've seen it done even in the most crazy situations. So I wouldn't count that out. I mean, I think that's something to consider if someone's looking to make a move. See if you can get incentivize the ex-spouse to move with you so that you're all together in the new state.
By hook or by crook, right, Stephanie? All right. Thank you, panelists. Kathy, I'm tossing it back to you.
Okay, thank you, Jonathan. Oh, wow, what a fascinating presentation. I'd like to thank Dennis and Stephanie, Mark, Laura, and Jonathan for putting this together. I know you spent a lot of time. Thank you so much. Excuse me, again, this does qualify for CPE credit, so I'll get those out to you today or tomorrow. And I will be sending out PAN membership renewal notices in December. So if you're not a member, please contact me. You can meet a lot of great people. We have some people representing some amazing firms. So I would love to have you as members. And other than that, let me think. Oh, as far as PAN, if you are not a member and just want to know more information, just visit mptf.com/PAM. Give me a call or email me. Either way. And I guess that's it. Everyone have a wonderful holiday season.
Yes, thank you.
Thank you.
Yeah.
Bye.
Bye.
Bye.